I'm the lawyer here, and I know that's a bit of a precarious job because your encounters with lawyers, I know anytime I'm in a group of health professionals, physicians, or the like, that your primary interaction with lawyers is probably in the malpractice context, which is an unfortunate context. I'm going to talk this afternoon about the equally fraught topic, though, of the First Amendment and of conscience, institutional, primarily conscience, but also individual conscience. And I should say, by way of also by introductory remarks, that while I do teach a class in law and bioethics at Villanova and have some interest and expertise in bioethics, I claim no clinical expertise. And so I look forward to the question and answer time that we have at the conclusion when we might think together about some of these questions I'm going to pose, drawing on your own clinical experiences. So just by way of introduction to this topic, conscience, of course, is a central but troublesome concept at the heart of Catholic moral theology and of the Catholic moral tradition. If you read some of the recent sort of historical treatments of Catholic moral theology, John Mahony's The Making of Moral Theology or the like, they discuss at length the role that conscience has played historically and still plays today in the moral reflections of the Church. You need only to look at the moral manuals of, say, a century ago that in some ways sort of became the launching pad, I suppose, for much of Catholic bioethics, Gerald Kelly and people like that from the 1950s. But going back even further to, say, the English Jesuit Henry Davis in his Moral and Pastoral Theology, he has this long chapter on conscience. There's all kinds of distinctions drawn about the properly formed conscience, the certain conscience, the scrupulous conscience, the poorly formed conscience, all these discussions about conscience and its place in the moral life. And of course, all throughout the tradition, there's this duty to form conscience, adequately informed by the Church and by experience. Interestingly, there's a similar place, one could argue, for the place of conscience in constitutional law. A little known fact is that the drafters of the Constitution, when they met in my now home city of Philadelphia to draft the Constitution, then later meeting to draft what became the Bill of Rights, that the language in the First Amendment that we know now as the Free Exercise Clause, protecting the free exercise of religion, was in various drafts of the First Amendment formulated as the free exercise of conscience. And so right at the outset, and it's interesting, when you look at the historical materials, the framers actually interchangeably, and without even thinking about it, interchanged the use of freedom of free exercise of religion and freedom of conscience in their debates and drafting of the First Amendment. And so there's at least, plausibly at least, an interesting intersection between the centrality of conscience, at least in the later Catholic moral tradition, and also the place of conscience in constitutional law, at least to some extent. But my topic for today is how we might think about conscience in Catholic healthcare and in constitutional law, both threats to conscience and perhaps opportunities for conscience. And so I want to talk about three things, basically. First is sort of rough and ready summary of some of the issues in the First Amendment, the law of the First Amendment, and the protection of religious freedom and the like, before this audience. And then second, to talk about some high-profile, controversial, and very difficult issues of conscience today in the law, and then conclude with some questions and observations. So as I said, I want to spend a bit of time sort of summarizing some of the relevant First Amendment law, realizing that it's going to be crude for anyone who maybe has a background in this. It's sort of like when you take the bar exam prep course before you take the bar in the summer after you graduate from law school. I remember there was a criminal law professor from the University of Southern California who was the teacher for the course I took, and he was marching through this 2-hour lecture of criminal law, and he summarized the elements of all the crimes. At one point he says, all right, kidnapping, 2 elements. You need a kid and you need a napping. Says, next crime, armed robbery or whatever. So there's a little bit of that quality here to how we're going to approach the First Amendment. But I do think it's helpful in thinking about these issues of conscience, both institutional and individual, to understand the background of First Amendment law that we have. So the text of the First Amendment, interestingly, doesn't mention, as I say, conscience, doesn't mention separation of church and state, which is how it's often interpreted. What it says is that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And it's that last part, the free exercise thereof, that almost became free exercise of conscience. As Chip Lupu and Rob Tuttle at George Washington in their Gianella lecture at Villanova a few years ago said, and this is a quote from them, "From American shores, church-state relations in Europe reflected episodic eruptions of bloodshed and tyranny. With great hopes for religious purity and civil peace, our founders agreed that the only way to break free from this destructive course was a new experiment, one that decoupled religious and civil institutions. This new government would have no jurisdiction over religious matters, thus ensuring the autonomy of religious institutions and simultaneously depriving those same institutions of any incentive to capture the organs of government to further their mission." And there are sort of four themes I want to sort of draw out of, and again, this is all sort of a rough and ready sketch of where the First Amendment interpretation by the Supreme Court and other courts has evolved today. The first would be, as I said before, this issue of separation of church and state, which isn't in the text of the First Amendment, which is the way that many of us understand much of what the First Amendment requires. And it's actually not as relevant or interesting for our purposes, but those would be all the cases involving restrictions on government funding for certain kinds of programs, for prohibitions on religious displays, on public property, prohibitions on school prayer in public schools and the like. The second, that I think which is more interesting and important for our purposes, is also, though, in much of the case law, an understanding of the ability of church and state to cooperate. So that in that same issue of funding, for example, and this is most fraught in the area of funding to schools, right, a few years ago in Zellman and Harris, the Supreme Court held that it was permissible in Cleveland, where the case arose from, for the city of Cleveland, the state of Ohio actually, to have a voucher program in which some parents would use their vouchers to send their children to Catholic or to parochial schools. And so there is, in the case law, this ability for cooperation in church and state. And of course, in the healthcare context, this issue has been long resolved with respect to Medicare and Medicaid funding going to religious institutions, right? There hasn't been really much of a live question for a long time in the case law that that's constitutionally permissible. It's not because it works, and there's no little doubt that it doesn't work in establishment of religion for Medicare or Medicaid funding to go to Catholic healthcare institutions, but that instead it's part of the license for cooperation between church and state that the First Amendment allows. And then there's a doctrine in the First Amendment law that we call the doctrine of church autonomy, which is that and this I'm going to return to, that the churches, religious bodies, the Catholic Church included, are protected from meddling in their internal affairs by the government. And so this comes up most frequently, for example, in cases involving the so-called ministerial exception, for example, that with respect to the hiring and firing of ministers, that churches have protection from state interference and the like.